Hey, welcome to Lecture 2 of Family Law and Policy. So there are three theories of marriage policy we're going to be looking at in this lecture. The first one is unity coverture that starts in the 17th century and moves into the mid-19th century. The second is the theory of separate but equal, starting in the mid-19th century and moving to the mid-20th century. And then finally, the theory of shared partnership in marriage, which starts in the middle part of the 20th century and persists till today. When we are learning about these different legal theories, I want to keep the following questions in mind. So when you're thinking about this as public policy, what can we learn about defining marriage in this way? What's the perceived problem that the policy addresses? How does the public policy address the perceived problem? Are there any benefits of defining marriage in this way? And what are some of the consequences? And what are the legal implications of this policy beyond marriage, divorce, and custody of children? And your textbook goes into more detail about custody and divorce and other examples of extensions of policy and the way that they've been influenced by these three theories. But in this lecture, we're just going to be taking a look at the three theories themselves. The first theory we're going to look at is the one called unity in coverture. And it stems from the English common law from the 1700s. That is the way that courts considered marriage and how they treated marriage and how that precedent in the court went on to sort of define how societies treated marriage within their common law or public policy. So there were two kinds of women. So one was known as femme sole, all the single ladies, and so that means a woman who is single, unmarried, versus femme couverte, married ladies, or covered ladies. That is, that they're sort of covered by the institution of marriage. And in the thinking about marriage through the unity coverture perspective, it's that married ladies really have very few legal rights. Their husband is dominant, the wives have very few legal rights and responsibility. And from society's perspective, that when a person gets married, they basically become like a legal dependent of the husband, sort of like a child, legally dependent in the same way. That under the theory of coverture in marriage, that it's one person. When a woman marries a man, that it becomes one entity. And so that in the eyes of the law, that there's really only one person that the state is dealing with. So how did the coverture understanding of marriage play itself out at the ground level in terms of policy? Well, at the point of marriage, all legal rights that a woman had were transferred to her husband. And this was what was known as the married woman's legal disabilities. And once you were married, there were many things that you couldn't do. And this actually might remind you of a case we read about earlier in the semester about the woman who wanted to become a lawyer, but she was married, and the state of Illinois said that she could not practice law because as a married woman, she had no legal identity. And so that was what was known as a woman's legal disabilities. So if once a woman was married, she could not own property. She couldn't engage in a contract or sign any legal documents. She could not obtain an education without the consent of her husband. If the woman was allowed to work due to the consent of her husband, the wages that a woman would earn would be the property of their husband. Children were assumed to be the legal dependents of husband upon divorce. And that the husband is basically legally responsible for the actions of the wife. And so that a tort is when an individual engages in physically harms somebody and then they are sued for that physical harm. That's what a civil tort is. And so if a woman physically harmed somebody in the actions of her day in and day out life, the suit would go against the husband, not against the wife, because the husband had no legal identity. And any debts that the wife would incur would be the husband would be liable for them since they were seen as one legal entity. Under the legal theory of coverture, one would wonder why a woman would get married given that she would lose all of her legal identity. And I think it is really sort of a reflection of understanding social norms and expectations at this time period, which went from the late 1600s until the middle part of the 1850s or so. It really was a sort of like idea that women did not have any sort of true autonomy, that they would go from the home of their father and then they would be transferred to the home of another man, their husband. And so it really does tell us a lot about the status of women. Well, what begins the erosion of the unity coverture theory of marriage? Well, first wave feminism. It has a lot to do with the questioning of coverture. Now, keep in mind that the first wave feminists held a women's convention in Seneca Falls, and remember that they wrote the Declaration of Sentiments, and this was in 1848. And the Declaration of Sentiments was fashioned after the Declaration of Independence. And in the Declaration of Sentiments at Seneca Falls, that marriage was seen as one of these injuries and usurpations on the part of man towards women. And that, they said that in marriage that man makes a woman civilly dead, takes away all of her rights to property or the wages that she earns, and is so framed in the same way in divorce as to be that upon divorce that she suffers the injury of losing the custody of her children. And so it was this sentiment that was, developed at first wave at the Seneca Falls Convention and first wave feminism that really got people starting to think about sort of the damaging impact of that this theory of marriage had on women, and also sort of rethinking, at least to a particular degree, sort of the rights that women have once they get married. Another and probably actually more important erosion of the unity coverture theory of marriage is the concerns that families had that upon marriage, if any property that was property of a single woman that was a part of her family's property legacy, once she would get married, that property would no longer be within the family, it would go to her husband. And it was that concern, right, not really recognizing that women should be treated equally, but rather the concerns over money that families had, that fathers would look at their sort of the property rights of their family, and they were worried that if their daughter married somebody who was bad with money or got in a lot of debt, and that debt needed to be repaid, that debt would be repaid by a forfeiture of the property that now became the husband's property. And so you'll read in your textbook about the Married Women's Property Acts in the 1830s that begin to exempt women's property from this coverture, right? So that in order to protect the property of husbands and families. But it really does sort of begin the legal process of slowly but surely sort of eroding this definition of marriage. Now, unity coverture is never overturned as policy, right? And that's not how policy generally works. I mean, that's part of the challenges about studying family law, is that because it's so piecemeal, there's not one comprehensive policy, that you have marriage law, you have adoption law, you have custody law, you have divorce law, and that it's different state by state by state. It really is a very slow process in terms of changing policy. And so, it's more of this slow erosion by piecemeal of overturning law, and that as laws are overturned and replaced with more equitable laws, that we see that there's this legal evening of the legal status between wives and husbands. Now, keep in mind, you'll read in your textbook that a lot of these laws that reflect unity coverture really stayed on the books for quite some period of time. And so even until the 60s, and sometimes they have the example in the textbook about the whether or not you can name your child an amalgam of your husband's last name and your last name. And in Tennessee, they wouldn't put that amalgamated name on the birth certificate because it was a reflection of that child was sort of the legal property of the husband. And, that was well into the 20th century. So it took a while for the illegal coverture to be eroded. But through the erosion of the piecemeal erosion of the laws that propped up unity coverture, we see the development of a new legal theory of gender roles in marriage. And this starts in the mid part of the 19th century and it continues to the mid part of the 20th century. And this is known as the separate but equal theory of marriage. In this, laws begin to recognize wives and husbands as having similar rights. Marriage is seen as a union of two individuals who are legally equal. However, even though they are legally equal and the woman actually has a legal identity by the state, that they're legally equal, but their responsibilities are different. Okay. And so that in the eyes of the law, they're treated the same. However, there's this assumption that the responsibilities within marriage are quite significantly different, and so that there is an assumption in the law based on oftentimes a stereotype that the husband is the breadwinner, the wage earner, and that the woman is the mother, the wife, the homemaker. And think back to some of the cases we read earlier in the semester, like the Frontiero case, where you had a woman who served in the Navy, and when she got married, she thought she was going to get extra benefits, right? But then they were like, oh no, only men get those extra benefits when they get married. Women don't get those, right? And so again, it's sort of like that she has a legal status, but the benefits that she gets is really sort of a reflection of the husband as breadwinner and wife as homemaker. So what begins the erosion of the separate but equal theory of marriage? Well, just as first wave feminism began the erosion of the unity coverture, second wave feminism, that as we know starts in the 1960s and into the 1970s, and remember that second wave feminism is the feminism that we had around the time of the ratification or efforts to ratify the Equal Rights Amendment. Second wave feminism and really changing the way that radically thinking about women as being equal and being treated equally in the eyes of the law. That really begins the change in thinking about that women and men have these separate responsibilities within marriage. Furthermore, there are economic changes as well, and so that in the 1960s and 70s, in large part because of deindustrialization, that is where we begin to see the loss of manufacturing jobs in the United States, moving overseas as we see the rise of a global international trade and economy. United States experiences deindustrialization, meaning that men who worked in factories often lost their jobs as those jobs moved overseas. There was increased need for women to be in the workforce. And so as women enter into the workforce in the 1970s, in part because of second wave feminism, but in part also because of economic realities, that those social changes lead to a rethinking of the roles within marriage, particularly if a man could not find a job who was working in a factory and their wife then becomes sort of the main breadwinner. Thinking about separate but equal roles, it seems to not line up with the real lived experience of couples within marriage. And so the final theory that you learned about in your chapter is the legal theory of marriage as shared partnership. And starts in the 1970s and goes to today. And when we do finally do our discussion on single nation, we'll be sort of exploring whether or not what would be sort of the fourth theory of marriage in terms of is this the shared partnership what's going to move into the future, or will there be sort of a refiguring of marriage, or maybe even just like an erosion of marriage as less people are seeing that as an avenue to or a entity to participate in. So in the shared partnership, that again, like separate but equal, husband and wife do have the same legal rights, but there's a shift understanding that regarding responsibilities within marriage. We see that the thinking socially is that those responsibilities are shared and overlapped, and that there's a change that difference in thinking about marriage is reflected in law. And so while in the separate but equal, laws would still sort of identify husband and wife, and when you're talking about spousal support, or where you're talking about child custody, or you're talking about divorce, right, and alimony, in the law it would be gender specific, right? The husband will do X and the wife will do Y. Well, because of this sort of understanding of marriage being a shared partnership where these responsibilities and rights sort of overlap, that gets reflected in law, and that changing the law to a gender neutral language really does move towards uniformity. You'll read in the textbook about how there was a wave throughout the United States to gender neutralize family law, and then sort of in that neutrality, sort of challenging stereotypes that judges might have as they were dealing in divorce, alimony, and custody. And that change in the legal language does help move towards at least a legal uniformity in terms of the legal theory of marriage. This third theory of marriage as shared partnership is not without critics. And probably the biggest criticism is that it's shared partnership in name only. That when it comes to custody of children, even though it is gender neutral for the most part, there's not parity in terms of custody for children. Or, even if that when a father seeks custody, there might be parity, but oftentimes fathers don't seek custody of children. And so we see that even though it may be gender neutral, those stereotypes about responsibilities don't necessarily play out in terms of the way custody is awarded. Furthermore, that when it comes to the shared partnership in name only, now when it comes to shared responsibilities at home, it's gotten better, but that it's still the gap between what women do after they get home from work and what men do after they get home from work, that we still see some gaps in terms of that shared responsibility. And so according to the Organization for Economic Cooperation in Development, when you look at the United States, things have gotten better, but there's this thing called the second shift. And the second shift is that after you come home from work, the second shift is the unpaid labor that spouses engage in at home. And that while the gap has closed, that women in the United States spend 4 hours a day on unpaid work, compared to 2.5 for men. And so women are, when it comes to housework, childcare, and those sorts of endeavors, women are putting in 1.5 more hours a day in those sorts of responsibilities. And that also corresponds with the reporting that men have more time for leisure activities, which would make sense if you have an extra 1.5 hours a day engaging in leisure activities like exercising and reading and just relaxing. That 1 hour plus is something that women do not benefit from. So obviously there's still some work to do, and maybe in terms of the redefinition of marriage, maybe it will come closer to a truly shared partnership, maybe with more contractual obligations as people engage in marriage. Okay, thanks for listening, and I'll talk to you again soon.